Good afternoon, Judge.
Good afternoon, Commissioner.
Omwanzo Mbati, karibu.
Asante.
Good afternoon, Judge.
Good afternoon,
Njoki Ndungu, representative of Supreme Court.
Good afternoon, Judge. Aiton Mrima. I wish you the very best, Judge.
Good afternoon, Honorable Judge. Fatuma Sichale, a representative of the Court of Appeal in the Commission. Karibu sana.
Good afternoon, Judge. My name is Olwande Evelyn. You're welcome.
Good afternoon, Commissioner. Good afternoon, Commissioner. Good afternoon, Your Honor.
I don't know why my mic is going off. Yes, once again, welcome, and we apologize for keeping you waiting. Our time overlapped, but I also noticed, happily, we've been joined by a sign language interpreter to help us with the sign language interpretation this time. So I welcome Madam Joki, who has joined us. Welcome.
Thank you, CJ.
So, Judge, we will start. If you could tell us your county and your ethnicity.
I come from Baringo County. I'm a Tugen.
You know why we asked this question, which is rather intrusive?
Yes, Chief Justice.
Yes, why?
For inclusivity. And yes.
Okay. Is it underpinned in the Constitution?
Yes.
It is. It's a constitutional imperative that we observe inclusivity, regional balancing, and all that, yeah? So we will start. You've been here before, so just make yourself comfortable. So that we can have a good discussion with you. We like to assure our candidates that we are not at all threatening. We just want to get the best out of you from the many questions we will be asking. So if you could start by telling us who is Justice Sergon, and if you could summarize the key achievements that relate to the position that you're applying for. In other words, how will you bring your experience, your knowledge, your skills to bear, taking into account the 5 or so jurisdictions of the Supreme Court?
Thank you, Chair. My name is Joseph Sergon, Justice Joseph Sergon, currently serving in the High Court Nakuru as the presiding judge. And I am a holder of a PhD degree in law, and an LLM and LLB degrees from the University of Nairobi. And I bring with me more than 32 years in progressive legal and judicial experience. I believe I am suitable to be appointed to the Supreme Court based on my experience and based on my experience and commitment to, based on my experience, my integrity, and the commitment to the rule of law. With time, I have developed research and writing skills, which are very, very important when it comes to judgment writing. I have also developed excellent communication skills, which are needed in the Apex Code. With time also, I have been a member of a task force, the AJS task force, which gave rise to the development of the AJS policy. So in terms of impacting on policy development and leadership in the judiciary. And I approach this position not as an achievement, but I approach it as an opportunity to serve the people of Kenya by upholding the Constitution and in the development of jurisprudence, which the Constitution requires. If given a chance to serve, the honor to serve, I will do it with diligence. I'll do it with diligence, I will do it with diligence and with hard work that will bring to the office. I also possess intercultural competencies which are necessary or need a judge to possess so that you are able to effectively communicate or relate with people from different or diverse backgrounds and cultures. I think in short, that is why I'm here. Thank you.
Thank you. Thank you, Judge. I think we will move to the next set of questions. I will ask Justice Ishale to take it from there.
Thank you, Honorable Chief Justice. Honorable Judge, I know that you're aware that every time we are doing these interviews and before the interviews, we ask the members of the public ability of candidates. In your case, we received 2 complaints. One is dated 14th of April 2026, which I believe the Commission alerted you of this complaint. Did you hear from the Commission?
I have not seen the 2 complaints.
No. The first one of 14th April 2026, filed by Ekuro Akot and company advocates on behalf of their client, one Paul Wanderi Ndungu.
I have not seen the yes.
I apologize for that, but possibly I could take you through the facts, and if you are in a position to remember this case, then maybe you can tell us what the position is or a response to what they are saying here. So the complaint in respect of this one is that they complain that you perpetrated sustained pattern of procedural irregularities and judicial misconduct, including the revival of lapsed ex parte orders, failure to prioritize a recusal application, and the irregular conviction of their client for contempt in a proceeding where he was not a party. Does this case ring a bell? The parties were Pevans East African Limited and others versus Nation Media Group Limited and others. Do you remember this case?
I remember, but I may not know the the nitty-gritties and details, but I remember having dealt with such a case.
Okay.
Yes.
So the first accusation is that you did extend ex parte injunctive orders, which you had issued on 2nd of February 2022, that's quite some time back, that had already lapsed by operation of the law. And secondly, that they had filed an application asking you to recuse yourself. You did not prioritize that application, but you went ahead to deliver a ruling in the same matter before dealing with the application for recusal. That also their client had filed a replying affidavit in the matter that was before you in a motion, but in your ruling you did indicate that there was no replying affidavit that had been filed. And that you found their client guilty of contempt of court, and yet their client was not a party in those proceedings. Are you able to remember the facts of this case and these accusations that have been made against you?
What I can say is that I know I dealt with the case.
Yes.
But the facts now, the facts and maybe proceedings leading to the decisions I made, I may have to look at the file itself, then I'll be able to objectively answer.
All right. This was actually sent to you via email on 23rd of April. And the email is sent to you attaching this complaint. But as you say, it would appear that you didn't get it.
Yes, I will need time maybe to peruse the file.
All right.
Yes.
And then there is also another complaint, unfortunately. This one is dated 1st of April, 2026. But we received it today from Eunice Lumala's advocate, and they're complaining against you. This was in the matter of Abubakar Hamed Talib versus Wiper Democratic Movement and 4 others. And the gist of their complaint is that in your judgment, in respect of that matter, you failed to take into consideration the submissions that they had filed, and that your assertion that they had not filed the submission was factually false, and that subsequently the judgment that you issued when an application was made asking that you stay your orders because it has very serious ramification, you failed to do so. Do you remember this case?
I remember, I think the case touching on, is it political parties?
Yes.
I don't know whether it's a case even which went to the Court of Appeal. And
yes, this one went to the Court of Appeal.
Yes, I remember dealing with this case.
Yes.
Yes.
So what do you say to those accusations that you failed to take into account their submissions? Number 2, you did not grant them an order of stay, notwithstanding the fact that the matter had serious ramifications, because I think one of the candidates was about to be sworn in.
It's also a bit tricky because if I can get through the file, the proceedings, however you notice, they acknowledge the fact that I clearly stated I did not have the submissions. I was honest myself, I did not have the submissions. Okay. Otherwise, I would not have just ignored. So I think it is a matter which I may need to look at the proceedings. Otherwise, I dealt with in the manner I did based on what was before me.
Yes.
Yes.
It's unfortunate that these complaints, you are not aware, they have not been brought to your attention before this afternoon.
Yes.
I think also persons who are complaining, I think it is important that they let us know in good time of the complaints that they have against the candidates so that we can also be able to advise you in good time.
Yes, thank you.
But we leave it at that. Now, I'd like to ask you one question. Having dealt with those issues of complaints, and in an article entitled Unyielding Voices, The Force of Dissent in Kenya's Evolving Jurisprudence by one Alex Wafula, he speaks of dissenting opinions or minority opinions that represent voices that refuse to conform to the majority voices. Judge, for the 32 years that you've been in the judiciary, have you had an opportunity to become, to arbitrate on a matter in a multi-member bench?
Yes.
All right. And in any of those instances, is there a time when you've had to do a dissenting judgment?
Thank you, Commissioner. In my case, I have not had a chance of doing a dissenting judgment.
Okay.
But what I know is in these multi-benches, because I remember the one dealing with the representation in JSC, we really had push forth back on to arrive at a decision. In fact, it took us about 3 sessions. We had to go to visit Naivasha several because it was a bench dealing with very, very serious issues on interpretation of the Constitution.
Okay.
So eventually we used the persuasion method. We discussed conferencing, and eventually we had a unanimous decision. Yes.
So must you always agree?
It is not.
Okay.
Yes.
So if that is a position that you don't have necessarily to always agree, what is the value, if any, of a dissenting judgment?
Yes, the value is, it's an expression of independence of, the judges, and it may also be...
So it is a demonstration of independence of the judge?
Yes, of the judge.
All right.
And secondly, it may also be of use in future in terms of when you continue developing the law. The dissenting judgments may give, a hint that positions may change, and a dissent will give the opposite. The different point of view of the other judges. You may use it in future in terms of either developing the law or, yes.
So it's usually a decision ahead of its time?
Yes, forward-looking.
And it can also be used in the world of academia?
Yes.
Does it persuade the majority decision?
At times, since it is forward-looking.
Yes.
And like now, where the fact that, like now, the Supreme Court, in future they may use it even when you want to depart from since they are not bound by their decisions, they may use it to, coming in future in case a new party files.
Okay.
Yes.
So because you are aspiring to go to the Supreme Court, any decision of the Supreme Court where there was a dissent, and in your assessment, when you look at it, you are able to say, this was a judgment that spoke to the future at the point in time that it was delivered. Give us one example or two.
I remember the decision on representation.
Gender representation?
Yes, gender representation.
2/3 gender representation?
Yes.
Who did a dissent in that judgment?
The dissent was done by Honorable former Chief Justice.
Former, we now have two.
Chunga. I mean, Mutunga.
Mutunga,
Yes,
correct.
Yes.
And what were the issues, or what was the dissenting opinion of retired Chief Justice Mutunga?
In a summary, his opinion was that we shouldn't wait for the realization of or the implementation of the 2/3 gender rule should be immediate, but not progressively as proposed by the.
So
by
the decision
majority.
of the majority that was of the view that there should be progressive implementation. Are we there as yet?
We are not yet.
Okay. So maybe we should have heeded the dissenting opinion of Justice Mutunga.
Time will tell.
It's been many years since.
You see, like even Parliament trying to grab up. You remember even the decision of, the advisory decision by Justice Maraga to dissolve Parliament and all that. So it is.
So, okay. Yeah. Finally, from me, in your view, what is the best way for the court when writing a majority and a dissenting judgment? How should they go about it? Should they do separate opinions, distinct legal reasoning? What do you think is the best way of going about it?
Okay, my view is, I think in order to develop critically, I think individual decisions, because unlike now the majority writing one, individual decisions could maybe better because you are able to decipher and come out clearly with what you.
Looking at for instance, an example of the BBI case, the 7 judges of the Court of Appeal, each one of them did write a separate opinion, and the same thing happened at the Supreme Court. So you think that's the best way to go about it?
I look at it as it's the best way because you are able to really get the nitty-gritties out of each and every judge.
Yeah, so today we were to find out from a judgment what the holdings of the court were. Which judgment do we look at? Because they have written separately, distinctively.
I like the last bit of where they summarize, the last bit of.
But remember, you've told us that your preferred way of doing this is for each judge to do a separate opinion.
Yes.
So my question is, where is the holding of the court?
I never saw that coming. It's food for thought.
Would you like to depart from what you have earlier told us?
I wouldn't wish to depart, but I think there should be a way in which maybe the president of the court will be able to. I don't know what tricks they apply because now to come out with a one decision, because I remember even.
No, thank you, Judge. I think the point is made.
Yes.
Thank you. Thank you. That's all.
Thank
CJ.
you, Commissioner Mwanza.
Thank you, CJ. Judge, I would want to refer you to Article 26 of the Constitution.
Okay.
That is the article on the right to life.
Yes.
And just so that we are on the same page, 26.1 provides that every person has the right to life. 26.2 states that the life of a person begins at conception. 26.3 provides that a person shall not be deprived of life intentionally except to the extent by this Constitution or other written law. And then 26.4 provides that abortion is not permitted unless, in the opinion of a trained health professional, there is need for emergency treatment or the life or health of a mother is in danger, or if permitted by any other written law. Now, Judge, on 24th of April this year, the Court of Appeal at Malindi delivered a judgment in the case of Kenya Christian Professionals Forum and others versus PAK and others. It's Malindi Civil Appeal number E039 of 22, in which the Court of Appeal ruled that abortion is not a fundamental right guaranteed under the Constitution. The learned judges of appeal also ruled that the Constitution provides exceptions in limited circumstances when abortion may be permissible. Now, I have 3 questions that I want to ask with respect to this judgment. Now, the first one is this. Do the restrictive circumstances contemplated under sub-article 3 and 4 of Article 26, that is, namely in the opinion of a trained medical professional, there is need for an emergency treatment, or that the health of a mother is in danger, or if permitted by any other written law, create a right to abortion? Does that exception, do those exceptions in sub-article 2, 3, and 4 in 26 create a right to abortion under certain circumstances? Now, the second question is, do the survivors of rape and incest have a right to abortion in the absence of the national legislation contemplated under sub-article 3 and 4? And lastly on this, should the right of abortion be considered as part of body autonomy that is constitutionally protected, particularly as part of reproductive decisional autonomy and the right to reproductive health, including access to safe, effective, and affordable methods of family planning, contraception, and sex education? That's my first question, Judge.
Yes, thank you, Commissioner. What I'm aware, okay, I'm just giving my opinion, but what I'm aware is that there have been discussions apart from the decision now from the Court of Appeal, which you have just alluded. What I'm aware is discussions have been going on the interpretation of particularly the restrictive bit of it, interpretation of the Constitution. And as to whether it is creating a right, the view I have is that I don't think it is creating a right. The view I have is that it is somehow giving you a reason. It's giving you, I don't know whether I can call it a reason or a ground in which you can do abortion. It's not creating a right of abortion because it is clearly bad from the first word, from the first sub article. Then the question of whether the survivors of rape have a right to abortion, they found themselves there. What I know is that there have been discussions on it by various, civil society activists, by also various victims of rape, that this one should be legislated. We should have legislation, or we should see how we can interpret it so that they have a right of abortion. But as of now, they the law does not allow them to have that right of abortion. But critically examining and looking at the circumstances in which the issue of rape takes place, it is my view that they should agitate for a right of abortion.
Okay.
Yes.
Now, Judge, in Article 4, that is 26.4,
Yes.
expressly obviously says abortion is not permitted unless in the opinion of a trained medical professional there is a need for an emergency treatment or the life or health of a mother is in danger, or if permitted by any other written law. Now, we've had almost 15 years or more since the Constitution was promulgated, and Parliament has not made any law to extend the permissible bounds, particularly for, the worrying issue we've discussed, especially on rape or incest. So should that be held against a victim who elects to commit an abortion? That's number one. Then number two is that if you look, for instance, in South Africa, where we borrowed heavily from, already they've enacted the Choice of Termination of Pregnancy Act. So they've actually actualized Article 26.4 in terms of if permitted by any other written law. So in terms of interpretation of the Constitution and developing the law, can one make a case that if Parliament, for one reason or another, has either abdicated or has not seen it fit to provide for a written law for those exceptions, then that should not take away the rights of members or Kenyan women who would want to exercise their right under certain circumstances?
Thank you, Commissioner. I think the way I look at it is perhaps when Parliament fails to enact these laws, perhaps maybe we can, what should happen is that the parties may have to take up the issue, the issue before the courts, so that now we are able to interpret the applicability of this provision. Like now, if one has committed the offense, of course, of abortion and is taken to court, perhaps that's where you can raise a constitutional issue. Then we file a suit. Then the court will step in to do the interpretation and see how best we can. Though the courts are not supposed to legislate, but to give a way in which you can interpret and save those rights that appear to arise in such circumstances.
Okay. Now, the second question I want to ask, Judge, is that with the advent of the internet, or the advent of the internet has enabled wrongdoers to violate private or public rights behind the veil of anonymity. The UK Supreme Court dealt with a similar challenge in November 2023 in the case of Wolverhampton City Council and others versus London Gypsies and Travellers. Now, in this Wolverhampton case, the Supreme Court, the United Kingdom, ruled on whether an injunction may be made against persons unknown. The Supreme Court was concerned that if injunctions are available only against identifiable persons or individuals, the anonymity of wrongdoers operating either online or through protests or such a sort of thing confer upon them immunity from the operation of the law. And the court affirmed that this is a new form of an interim or final injunction permitted in equity. and it allowed it to be applied against what they called newcomers who arrive at site after a case has already begun. Now, my question is as follows. Does the High Court, or will our High Court, under developing the law and under the doctrines of equity, some of which have been imported through the Judicature Act, possess powers to grant an injunction which binds persons who are not identifiable at the time the order is granted? And if so, what basis or subject to what safeguards? Considering that in the United Kingdom case, it stated that the High Court has power to grant injunction because circumstances have evolved over time, and therefore the law on injunction ought to be developed. So can one make a case that we can develop now our law from, when we started from Giela and came all along, and now address these new situations which seem to have evolved because of either technology or the way the world has changed?
Thank you, Commissioner. I think this is a new area which I think I read also this case.
Yes.
And for us, of course, we don't have the enabling legislation to issue such orders. However, you realize the UK case, the courts were just being innovative upon being prompted to expand the sort of orders issued and against which particular parties. So for us here, I think unless we are prompted so that we can go beyond that.
The court actually developed that law through the doctrines of equity and say that circumstances have evolved, and therefore, it sort of moved further ahead and said the court can actually give injunctions, an injunction against unknown persons, and actually against a cause of action that has yet to arise.
Yeah, so that has been the court being innovative,
yes.
And I can see this happening, like even the latest Supreme Court decisions. You saw the one of where we are moving away, like rights, the rights of an innocent purchaser for value. And the Supreme Court has gone beyond that and said now we have to look at the basis or the basis of the whether this lawful, whether the original owner had acquired legal rights, because if the title is questioned, so you can see these issues like the one you've raised, we can actually develop with time. But for now, you cannot say the High Court can issue the orders, but we can be innovative and develop the law.
Okay.
Yes.
And lastly, Judge, I want to take you to a case you decided.
Yes.
In the case of Kabuitu Contractors versus Attorney General.
That's the one I think last time when
yes,
I was here.
Yes. I don't know whether perhaps you had time to look at it. Then it sounded a bit new.
Yes.
Whether you were able to reconcile the fact that in this case, the amended plaint pleaded for a sum that was claimed against a breach of contract for 1.12 billion, and you granted at the end a sum of 3.1 billion. I don't know whether that you've been able to reflect whether this was correct or under what principle you were able to escalate this award from what was pleaded to almost 3 times the amount that was claimed.
Okay, thank you, Commissioner. I think I have not had time to look at it.
Yes.
But what I know is that the answer I gave that time, based on the facts that were given to me.
Yes.
And the fact that even the defendant did not really appear to challenge.
Okay.
Yes, to defend. That's how I came in. But if given time, I can still relook at it.
Okay.
Thank you.
And lastly, in terms of the collegiality that is required at the Supreme Court level, what is your view about what informs a decision? Is it the strict interpretation of the law? Perhaps when you have unanimity in a decision? Or is it that, just like Parliament, there is an element of persuasion where judges or a college of judges within the court have to persuade each other, search for compromise, and take strategic positions in terms of how to reach or to arrive at what the meaning of the law is, or how to resolve a dispute?
Thank you, Commissioner. I think this one basically, in the earlier answer that I gave Commissioner Honorable Justice Sichale, if you write your own judgments, individual judgments, at the end of the day, of course, there should be a forum where you are able to agree on various aspects of the case. Then, so that now the question of collegiality comes in, because you're doing your work, but you have a different way, or you have your own judgment, and now when it comes to the collation of this, when you collate the judgments, then you are able to say, okay, this one that is the different way I'm looking at it. I don't know the style of now the Court of Appeal or Supreme Court, where now, of course, they do conferencing.
Okay.
After conferencing, they are able to know maybe which particular, which particular line are you going to take. Then I think.
Okay.
Yes.
Just to conclude on my questions, and following up from what Justice Sichale asked, the criticism that has been made by the critics of the court is that the court seems to have almost a 95 or 98% unanimity in terms of arriving at decisions. And there are those who say that it's because the court is seeking for coherence, a doctrinal coherence, so that they give, they need to guide the country about what the law says. But what is your view about these critics who say that there is a rarity in terms of dissent at the court?
Thank you, Commissioner. I think that, of course, criticism is valid. However, you see arising from the conferences they do. They may agree on a particular position they will take as a court. And what I know is that at times they agree, and then they give one or two judges to now prepare the lead judgment, so that now when they reconference again, they will be able to have a unanimous decision, which is now different from what I was saying. But if everyone could write his or our own judgment, perhaps, and then we have a forum where the court can conference and say, this is the position or this is the decision, then they give a summary. That could be maybe the best way to deal with it.
Okay, thank you, CJ. That's all.
Yeah, thank you very much. We now move to the Honorable Attorney General.
Yes, good evening, Judge.
Good evening, Commissioner AG.
Yes. You know that in 2017, we had a presidential election petition.
Yes.
And on the 1st of September 2017, the Supreme Court issued a decision annulling the presidential election by a vote of 4-2. Yeah?
Yes.
I want to read you a quote from the majority judgment. Quote, "The greatness of a nation lies in its fidelity to the Constitution and strict adherence to the rule of law, and above all, the fear of God." Now, you can see the Supreme Court in 2017 has introduced a new threshold that requires substantial compliance with the Constitution, that is fidelity to the Constitution, the rule of law, and the fear of God as guiding principles in determining the validity of presidential elections. Should the Supreme Court encourage the use of extra constitutional and controversial parameters such as fear of God in determining the validity of a presidential election?
Thank you, Commissioner. I don't know whether that was the ratio decidandi or the ratio in that case when that comment of fear of God. Because I thought that one was just, the comment made outside, but otherwise the decision itself had
I've read it from the judgment.
Yes.
It is from the majority
Which
judgment.
was a statement. I don't think it was the basis of the decision.
But since it was a statement made and written, it
Yes.
must have persuaded somebody. Yes.
I will leave it as, if it's me, I don't think it really, to me, I don't think it really influenced the Supreme Court, that statement of fear of God, fidelity to the Constitution, but I think it was a statement to me which was out of context.
Fair enough. Secondly, in your introductory remarks, you spoke about the rule of law.
Yes.
What exactly did you say?
Okay. When I was introducing that.
Yes.
Because I remember I was saying promoting the rule of law.
Now, the rule of law is a fundamental principle in most modern constitutions. Just before I ask you, your PhD is in which branch of the law?
PhD is in alternative justice.
All?
Alternative justice.
Alternative justice?
Yes.
Okay.
Yes.
Now, the rule of law is a fundamental principle in most modern constitutions. For example, the Constitution of Kenya is actually a core value. However, universally, we don't have a uniform, agreed definition of the term rule of law. Now, you referred to it. You can see even in the election petition, they're talking about fidelity to the rule of law. What are the challenges of having a uniform definition of the rule of law? One. Secondly, I would like to know your understanding of the term, the principle, or the value of rule of law. And would you just tell us the manifestations of the rule of law in our Constitution and how, as a High Court judge, you will uphold and evidence the rule of law?
Okay, thank you, Commissioner. I think when you talk about, of course, we don't have a unified definition of rule of law. What happens is that we have several principles that you put them together, then you are able to say, I am applying the rule of law, right of hearing, right of fair trial, and all those things. Then, so you'll say, okay, also respect for the, like when you have to implement the decisions of the court, all those aspects. Rule of law is a very wide area where you really have, you don't have a one definition, but you have various principles that comprise a rule of law. Then you're saying about the challenges. So I've just said there is no one definition of the rule of law. So that now the element of challenges facing, challenges of having a definition may not, as of now, be given an answer. Thank you, Commissioner.
What are the manifestations of the rule of law in our Constitution?
Okay. When you look at the Constitution as a whole, it has identified various rights that arise. It has identified also issues that, you see, like now when you look at like Article 50, right of hearing, right of fair trial, and all those aspects. So that, as you say, was there a rule of law? Were these, were these principles?
Is access to justice a manifestation of the rule of law?
Yes.
Provision on access to justice?
Yes.
Are the provisions on separation of power a manifestation of the rule of law?
Provision, separation of power?
Separation of powers.
Yes, it is. It is.
So what are the other manifestations of the rule of law under our Constitution?
Okay, I may not get it off my mind now.
Correct.
Right now.
And why do you think that there is a difficulty in having a universal definition of the rule of law?
Because it has several facets. It has so many principles that you can't lump them together as one.
Would culture and religion be one of those?
Of course, if you have a right to culture, you have a right to, it is one of it is. If like now, if you are entitled to.
As a Supreme Court judge,
yes,
how would you uphold the rule of law?
Okay, I will uphold the rule of law by applying, of course, the principles laid out in the Constitution. Yeah. Because there is no one definition that you can say, this is how a Supreme Court judge can, or a judge for that case, can apply. It's just a question of identifying what are these principles, how are they supposed to be implemented and all that. So it's not a straitjacket, say, of getting, getting the rule of law implemented. It's a question of identifying all these principles and then apply.
But don't you think it is vitally important for a judge of the Supreme Court to at least have a view of how they will implement? For example, if the rule of law means that we will be ruled by law, and it is law that has been promulgated by Parliament and written in statutes and regulations, can you go out of that law in interpreting the Constitution?
Thank you, Commissioner. That's what I'm saying. I will apply the principles set out in the Constitution in furtherance of the rule of law. And all these principles are scattered all over the Constitution. So, that's the way out.
Thank you.
Thank you, Commissioner.
Thank you. We now move on to Justice Murima.
Okay, thank you, Honorable Chief Justice and Judge. Once again, welcome.
Thank you, Commissioner.
I need to get your view on how you will approach this issue. We are aware that in the Supreme Court, there are some decisions which are divergent, and the effect of that is that the courts, which are bound by the decisions of the Supreme Court, these decisions appear to be conflicting, like the interpretation given to Section 83 of the Elections Act in the 2017-2013, and maybe some other instances where we see this manifestation. Now, once you are successful, Judge, and you join the apex court of this country, one of the purposes of this court is actually to settle the law and to give certainty and to give direction to this country. That's the principal role of this court. Now, what will you do, or how will you propose to go about reconciling these instances whereby we have divergent decisions in the Supreme Court? How would you propose to deal with them so that down the COA and the High Court and the rest of the courts, there's a certainty?
Thank you, Commissioner. This is rather a very dicey situation because the court has to identify, or this is the conflicting decisions or divergent decisions have to be identified as to how they can go back, because the Supreme Court has the latitude of not being bound by their decisions. So it's a question of me now identifying, if it's me, identifying how can the court deal with these divergent decisions. Because what I know is that the principle of harmonizing decisions or conflicting decisions in the Court of Appeal is done by the Supreme Court. But now this is an issue where the Supreme Court itself has some conflicting decisions, and perhaps an action or there must be a way of having it, brought before the court so that they are able to apply the fact that they are not bound by their decisions, and then relook at and then harmonize those decisions. But it is something we need to identify, or the court has to identify how to deal with such a situation, because I don't know whether you can approach by way of review. It's very tricky. It's very tricky.
Okay. Now, taking the discussion further, let's now go to the Court of Appeal, and we have a scenario where we have the divergent and conflicting decisions in the Court of Appeal, and we know that there's a window for such to be reconciled at the Supreme Court. But that window can only be opened through the appropriate law, where you have to get a certification by the Court of Appeal or by the Supreme Court. Now, in instances where none of the parties at the Court of Appeal, the parties who appeared in the matters before the Court of Appeal, none of them is willing or intent on requesting the Supreme Court to look at these decisions. Can the AG, and we take it that the AG is not a party in these matters, can the Honorable Attorney General move to the to the Supreme Court and seek to have the court look at this matter in public interest?
That's a bit because now there is no provision that will allow the AG to just step in and move the Supreme Court.
Yes, but Judge,
yes,
before we proceed further, the Constitution gives several functions for the Honorable Attorney General, and one of them is to defend public interest. Can the AG step in and say, I'm defending public interest here? There's a confusion in the Court of Appeal. It needs to be sorted out for purposes of giving proper clarity and direction in law.
Perhaps if we can be innovative that way, it will now depend on how even the Supreme Court will appreciate that innovation by the AG.
Okay.
Yes. So, but it's a very good proposal where we can be innovative. We can prompt.
Okay. Now, Judge, these are the issues which you need to prepare yourself in advance to encounter if you are successful. Very difficult issues, but they have to be sorted out.
Yes.
By the SCOC. Now, let's move from that to issue of review. If you look at the law generally on review, in the Supreme Court, there is an act and a specific provision for review. Likewise, in the High Court, there is an act and rules specifically providing for review. But that may not be the position in the Court of Appeal. Now, in the absence of a specific provision of law in respect of review, what is the legal basis of the Court of Appeal exercising a review jurisdiction? Because it used not to, but of late, due to some developments, the Court of Appeal now entertains review applications. What do you think is the legal basis of that?
Thank you, Commissioner. I will approach it this way. Okay, as of now, we have, of course, a decision which clearly stated that there is a small window opening for the Court of Appeal to do review. However, so that one we can use that, but however, for now, the proposal, because I know as we speak, what I'm not sure is whether the rules, the Court of Appeal rules have been reviewed of late, because now we may have to look at it and then have the rules, the Court of Appeal rules be reviewed so that you can include the question of review.
Okay. No, Judge, I'm in agreement with you, and you are right to say that the court has opened a limited window for review. Now, in that discussion or that decision by the court, what did the court rely on to open that small window? What did it say it's based on? Which is this power which this court exercises on that review?
They were talking about the residual power, that the residual inherent power,
yes, exactly,
that the court can exercise.
Okay.
Yes.
I think, Judge, I'm okay with that. I just wish you the best. Thank you.
Thank you.
Thank you. We move on to Commissioner Ngutia.
Thank you, Chair. Good afternoon once again, my Lord.
Good afternoon, Commissioner.
I hope you're doing okay.
So far, so good.
Okay, do you need some water break or we proceed?
I think we can proceed.
Okay, good to hear that. So, my Lord, you did submit to us a chapter of a book titled Effect of Legal Transplant on Customary Law in Kenya. And you also submitted a journal article on strengthening the application of IJS in land disputes and decisions of cases you've handled in murder, constitutional petition, and succession matters. Both scholarly and judicial outputs, you exhibit excellent issue identification, clarity of structure, with a strong ability to link legal principles to either factual disputes or social legal realities. I was particularly impressed with the conclusions in your book chapter, where you emphasize on the need for coherent and context-sensitive approach when it comes to reconciling customary law with
constitutionalism, and you warned against over-reliance of transplanted doctrines within our Kenyan context. So I commend you for that. Though I note that that decisions, the 3 decisions you shared, they do not bring out new legal principles. Maybe you could share with us any matter that you've handled that was groundbreaking or that supported the development of jurisprudence in the country.
Okay. I'm reluctant at times to quote specific.
Maybe just one. You could maybe just share one.
Specific questions. Perhaps maybe the one that comes to mind is where it involves on the membership, not membership, representation in JSE by members of KMJA. Mm-hmm. That's where critical issues arose. One, the Constitution talks about the members of an association of judges and magistrates, and one be a male, the other one a female, and one to be a magistrate, the other one to be a judge. And by this time, we have a new cadre of courts. We now have judges of ELC, judges of ELRC. So now the question is, if you are saying you want to elect a judge to represent the association, and the Constitution talks about a judge of the High Court, and it didn't envisage a situation where we'll have a ELC judge, ELRC judge. So we're called now to interpret what is the definition of a High Court judge in the context of this dispute. So we had to really grapple up and down, and then eventually we came and said, okay, the Constitution envisaged that the High Court in courts of equal status, the High Court judges and courts of equal status, the Constitution envisaged a situation where the judges will be, the High Court judge will be one and the same as referring to ELRC and ELC. And then, of course, the other issue was whether you see, Supreme Court judges, Court of Appeal judges elected their own representative in JSE directly. Then at the same time, they are also members of KMJA. So the question is, are they entitled to have a right to elect, to participate in the elections of these representatives, as the magistrates and the judges representing KMJA? Of course, we came to the conclusion that no, they cannot have a second pick of the cherry. So that's how complex it was.
Oh, okay.
Yes.
Thank you for sharing. I thought you would also share the recent decision after the BBC Africa Eye documentary, Sex for Work, The True Cost of Our Tea, where you held that Chapter 6 and the Bill of Rights is also applicable to private entities, and in that context, that was the private tea factories. So again, I commend you for your thoughts in that particular matter.
Thank you.
There is this decision, the Francis Wambugu Mureithi versus Owino Paul Ongili. That's Babu Owino matter,
Yes.
The 2018 matter where you nullified Babu Owino's election and ordered for a fresh election. And on appeal, the Court of Appeal reversed your decision, finding that whereas there were irregularities, they did not meet the threshold under the Elections Act and the Constitution, and the Supreme Court further upheld the decision of the Court of Appeal. Though I took note that the Court of Appeal mentioned that your decision had no legal premise. What is your take on that criticism or feedback, or I don't know what name I should give, by the Court of Appeal, and what happened thereafter, not just for this matter, but moving forward?
Yes, I think, of course, I had time to look at it. And, of course, that was harsh language. But nevertheless, I've learned from the decisions of the higher courts.
Okay. What is your understanding of harsh language?
You're saying illegal. I mean,
had no legal premise.
Had no legal premise, and
like no
of course, I must have had a basis.
Mm-hmm. So
yes.
I just want to understand your understanding
yes.
of harsh language.
Yeah, that's what I take it to mean. It was a bit harsh.
Okay. Again, the Supreme Court, this is still linked to elections. They have established specific principles on burden and standard of proof, and also threshold when it comes to nullifying presidential elections. So in your view, has the court been consistent in applying the standards and the threshold?
Yes, I agree. The Supreme Court has said
has been consistent.
Yes.
And do you think the finding is okay, or should it be maintained? Should it be refined or recalibrated, or it should remain as is?
To me, it should, depending on the circumstances of each and every case, those principles can still be refined and going forward, because it depends on each and every, facts of a case.
Okay. Lastly, Article 20, Sub-Article 3 of the Constitution stipulates that in applying a provision of the Bill of Rights, a court shall develop the law to the extent that it does not give effect to a right or a fundamental freedom. And also Article 259(1) and C, the Constitution commands that it shall be interpreted in a manner that promotes its purpose, values, and principles, and permits the development of the law. Are we together there, Judge?
Yes.
So there is 220, Sub-Article 30, and Article 259, 1, A and C. So it does expressly provide as to how the Constitution should be interpreted. And there is an argument that the provision on permitting the development of the law grants judges a legislative function. So what is your understanding of development of the law, and is it different from making the law?
Okay.
And how would you draw the line?
Thank you, Commissioner. What I know is that when it comes to the issue as to whether judges are legislating through their decisions or not, it is an issue which is so controversial, and it's an ongoing debate. But we prefer always to say, okay, the judges clarify the law, they interpret, but when it comes to legislation, I think the way I look at it is when judges make decisions and say you refer now this one to Parliament to amend according to the recommendations from the judiciary, then that is maybe where you can define and say, yes, judges are legislating. But strictly speaking, judges are just basically interpreting the law. They are unable to legislate. That's not their mandate.
Okay, and are you aware of any Supreme Court decision that has used those two twin constitutional clauses to develop the law?
I'm aware, but it doesn't come to my mind clearly.
Okay, thank you, Judge, and I wish you the very best.
Thank you.
Thank you, Chair.
Thank you very much. We now go to Justice Njoki.
Good afternoon again, Judge.
Good afternoon, Commissioner Judge.
Okay, now, one of the most well-known jurisdictions that the Supreme Court has is the determination of the presidential election petition. As you know, there is a constitutional timeline. Once declaration has been made, the petitioner must file within 7 days, and then the Supreme Court must determine within 14 days. Now, there is a regulatory timeline also to be found in our rules so that the Supreme Court is able to manage the short time that we are given. Are you familiar with the regulatory timeline?
Yes.
Please, can you take us through it?
The regulatory timelines basically is, okay, the presidential petition has to be, from the date of filing, has to be dealt with within 14 days, and heard and determined within 14 days. And then the filing of the responses, I think. The first one is you file and then serve. Okay, I may not have the details so much, but what I know is that the cumulative effect is that a presidential election has to be filed and heard and determined within 14 days.
That's what I was trying to say. There is the constitutional timeline.
Yes.
And then under the Supreme Court rules, we have a regulatory timeline by which time the petitioner must serve the respondent must return, the time for interlocutory matters, so that we are able to hear the matter. Okay.
Yes.
What about the form of evidence that the Supreme Court will consider, given the time? What is how does evidence present itself in the Supreme Court? In normal election petitions,
yes,
you'll be able to examine and cross-examine witnesses.
Because I've seen.
So what is the form?
Affidavit evidence.
Affidavit evidence and what else?
And then submissions.
Submissions?
Yes.
Yeah. There's also a statutory requirement that asks the IEBC to submit all the forms within 48 hours.
Yes.
Okay. Assuming then you're in the Supreme Court and we listen to the presidential election petitions and we have concluded, what are the possible orders we can give at the conclusion of the case?
Depending on, at the conclusion of the case, it's either to nullify the election or to dismiss, of course, the petition if you do contrary.
Okay, so assume we find the election was valid.
Yes.
So that is one way of doing it. What if we find that the election is invalid? What next?
Okay, if you find the election is invalid, then you have, of course, the discretion or the power to order for repeat elections.
Okay.
Yes.
Can the Supreme Court recount the ballots?
if there is an application, I'm not very sure, I'm not very clear on that.
Oh, okay.
Yes.
Because it has 14 days to make a decision. So can they count the ballot after making a decision?
I don't see any provision for them to form a recount, yes.
So the only option is to?
Order for a repeat.
To order for a repeat.
Yes.
So this repeat, would it be a fresh election or a runoff?
Okay, it will be a fresh election. It will be a fresh election, but of course, depending on, because if we say a fresh election, what I'm not very sure is whether any basis on like nomination was done, whether the decision found something on the nomination of the candidate or not, so that now, if it is a fresh election, then the same parties
That is a question that the Supreme Court has answered.
Yes.
So who would participate in a fresh election?
The parties who were competing in the election that has been nullified.
Okay.
Yes.
Now, coming to the issue of collegiality and also character, although I think most of the issues I wanted to ask on collegiality have been asked, but let me start with that first. I don't know whether I know this question was put to you by Commissioner Sichale, but I don't know if we teased it out completely as to what the importance of a dissent is. Is there any importance of a dissent, apart from a judge having a different opinion?
Okay, the importance of what I know is that the importance of a dissent judgment, one, it gives a different view. It takes a different view of the majority judgment, and then it may be used in future for development of jurisprudence.
Okay, I think that is correct. Coming to character, one of the things that is required of a Supreme Court judge is to be courageous. Because when you are at the final court, making final decisions in a political court, you will be vilified. You will be trolled in social media. You'll be dragged to the Judicial Service Commission. You will be exposed together with families. You are pushed into a life which is not social at all. Are you ready to give up the life that you live in order? Do you have the courage to face this? And have you had an experience which you can share with us in which you are able to show us that you can withstand high octane and high pressure?
Thank you, Commissioner, Judge. Yes, I'm ready and I will be courageous. I can give one experience I've had without, of course, mentioning the parties and all that. Because here we have a case where a party is hell-bent to not to prosecute his or her case, and will apply all sorts of tactics to ensure that the case does not proceed for hearing. And one of these cases where I dealt with, the CJ had to allocate me personally to deal with it. And having 5 judges having disqualified themselves, not because they had an interest in the matter, but because of the manner in which the plaintiff or the petitioner was conducting himself. He did not want at all to proceed with the matter. He would create a situation where he would abuse you. He would create a situation where he would complain. So I was given specifically to deal with such a matter. And it was so octane. It was just, you couldn't withstand the abuses, the complaints, and all that. Then I took up because everyone had disqualified themselves, five judges, senior judges. So I took up the matter. Then I said, I will apply my persuasiveness, my patience, my courage to also face JSC when they complain. And by that time, normally when there is a complaint, JSC quickly will just write to you, can you answer this, can you answer this? But eventually I applied patience, courage, and all other, tactics. Eventually I finalized that case. I did not send it back to the CJ, and it was concluded. Thank you.
Okay, thank you for that answer. Finally, I've seen that you are well experienced on mediation, and it's something that you encourage. Now, in the Supreme Court, during a presidential election petition, is mediation something that you would recommend for the Supreme Court to first use with the parties before proceeding on with the matter? As you well know, for the elections in 2007, 2013, 2017, and 2022, the parties who were on opposing sides in the presidential petition eventually reached some agreement. Therefore, is this something that you would encourage upfront so that mediation might be an option rather than to go to an adversarial hearing of the presidential election petition?
Thank you, Commissioner, Judge. The only problem we have here is the law does not envisage mediation to come in play, and the timelines also in which you're supposed to deal with the matter. But as to how the mediation can be done.
But the Constitution itself encourages us to have mediation. Or do we need a specific law?
I don't think so. What is happening, what my only worry is these timelines. Mediation can be encouraged. But if you send the parties now for mediation, will time stop? That is the other challenge that we will have. So otherwise, I agree, we can engage the parties to go for mediation.
Thank you very much, Commissioner Rwanda.
Thank you, Chair. Good evening, Judge. It's evening now.
Good evening, Commissioner.
I was a bit worried when you said there's no law that allows you to carry out mediation, because I know those are the guidelines we are given for the exercise of judicial authority, isn't it?
Yes.
Okay, so to start us off, I want us to look at your performance report. I don't know if you were given a copy.
I think it was sent yesterday.
Okay, great.
Yes.
So now I've looked at the report from DSPOP. I think you're doing a good job generally when it comes to case clearance rate. It's easier to rate your performance at individual level because you sit alone. Maybe to start off, you were in Kericho until when?
I was in Kericho until 1st of April.
So it's a few days ago that you left Kericho?
Yes.
Yeah, the report I have is basically about Kericho.
Yes.
And your case clearance rate is at 106%, which is quite commendable. But what is of concern is your backlog situation. From your pending cases, 48% of your cases, almost half the cases are backlog. And it got me wondering what is your way of work, especially when it comes to case management, to ensure that you clear backlog, because it doesn't look like there's a lot of work going on there.
Okay, for this one, I can say what we have a problem in terms of cleaning the system. Mm-hmm. Most of these cases, most of them are not pending. But I think the question of clearing the system itself, that's where the problem arose. So we have a problem in identifying matters which are pending and matters which are not pending. So as such, we don't have a backlog, but we have a problem looking at our system. So we have that problem there.
Is it the automated system, or is it the case audit that is not tallying with what you have?
The case tallying that we've done, and then
the case audit.
Yeah, the case audit. Yes, yes, and
what
it's still ongoing as we speak. As of now, we're still doing that. But what I know is that we've really cleared the backlog. It's a huge. When you get now the real figures, you'll be able to know that we've done a lot of work.
Okay, thank you for that. The other question I wanted to engage you on, if you look at our performance appraisal system as Kenya, the jurisdiction, we focus mainly in disposition time. Even as we are going about working on case waiting, our focus is mainly on disposition time. We have other jurisdictions that also take into account the reversal rate. A case in point is our neighbor here, Rwanda, not too far away. And I think also the Netherlands, I think also does that. I just want to hear your views on this. The challenges of relying on disposal time and the challenges of relying on reversal rate, and what we can do about them in terms of striking a balance.
Thank you, Commissioner. I think the issue you have raised is very critical. If we can get the best practices, we can borrow, then we utilize here so that we are able to really look at objectively how we can improve our performance. So I did not know that idea or that knowledge about our neighboring country, but I agree. We can borrow the best practices in terms of looking at this.
Yes, like in Rwanda, they compare the number of cases or decisions from a particular judge or judicial officer that have been taken up on appeal and the number of times they've been upheld.
Yes.
What is the challenge with that kind of system in terms of evaluating performance? And also the system that we have here, where we're basically focused. You know, when you're talking about case clearance rate, backlog clearance rate, delivery of judgment within a certain time, all of it is focused on disposal time.
Yes, and you see that
disposition time.
Commissioner,
yes.
You see that is the challenge we have, because I remember even recently we had, when we had the High Court conference, that issue came in, so that even when you look at the disposal rate, you have to look at the weight of the case also.
Yes.
Yes, you have to, so that there are situations where a judge can dispose of so many, but they are just light files. But you look at now those heavy files, there are situations where a judge may not even finish a judgment in these heavy files within a year. So those best practices should be done so that
that is a challenge with the focusing on disposal time.
Yes.
That we need to factor in the case waiting.
Yes.
That's what I hear you to be saying. Any other challenge with the focusing on disposal time?
The other challenge also, apart from that, is you have to look at also other factors, like what are the reasons. Other factors like now, maybe a judge is on leave, a judge is sick and all that. So I don't know whether such factors come into play when they are doing these, assessments.
Okay.
And transfers also, of course, come in play.
Okay, what about the reversal rates?
The reversal rate...
The challenges with that, with focusing on reversal rates.
The challenge on that is, it will also mirror in like this other one. You look at also the weight of the file. It's a bit tricky because it may not give a true picture of what, because now the reasons for the reversal, you never know what was it all about. So you may not use that one as a very good index.
Okay.
Yes.
Okay, thank you, Judge, and I wish you well. Thank you, my lady.
Yes, thank you. Thank you very much. We now move on to Commissioner Nzeran.
Thank you, Honorable CJ. Judge, I have two questions for you. Now, Senior Counsel, Mr. Elisha Ongoya and other scholars have proposed the establishment of an annual academic review where Supreme Court's jurisprudence each year is critically examined. Would you support such a forum? And if so, how would you engage with it? And what value do you see in the informal academic critique of the court's decisions?
Thank you, Commissioner Ntilani. I know it is a proposal which we shared in a meeting we had with Elisha Ongaya, and it's an idea which its time has come, and I think it is important to, like I was going through the decisions of the Supreme Court at 12. You have a catalog of cases which were decided and some analysis. I've also read like the book of Supreme Court Sets the Law by Dr. Ndegwa. And I think I like this idea. If we can do this, it will improve us from doing our, improving our skills, research skills. Yes, and judgment.
Is there any other value that this exercise would add?
I think basically it will just sharpen our skills and also apart from the academic, academic performance, academic achievements, then I think that could be. Yeah.
Okay. Please describe a situation in your career where you had to take a position in judgment or ruling or public stance that conflicted with your personal beliefs, your professional relationships, social environment, or political views, and tell us how you handled it and if there are any lessons you picked from the same.
This one, I seem not to have one in mind for now.
Okay. Okay, finally then, if you were to identify three most significant challenges currently facing the Supreme Court of Kenya as an institution, what would they be? And what role would you play in addressing them if you're appointed?
I think one of the challenges that may or likely to face the Supreme Court, one is a question of question of technology. Are we applying seriously technology, particularly like the innovation of application of ICT in in their day-to-day. I know they are paperless, but I know we have challenges in the question of automation, the entire thing. That's one thing I look at it and say, okay, we may need to improve on it.
Any other? I asked for 3, you've given me 1.
The others, I think it will come home. I may not get now right away.
Any jurisprudential challenge?
Yes, maybe the question of, it was raised earlier on conflict of decisions by the court. There are conflicting decisions. Maybe that's something, and so the challenge comes in: how do we harmonize? How do we correct that scenario?
Okay. Thank you, and I wish you the best. Thank you, Chair.
Thank you very much, Commissioner Kisot.
Thank you, Honorable Chair, and welcome again, Judge.
Thank you, Commissioner.
Suppose a senior government official publicly attacks the integrity of the Supreme Court after losing a case. Should judges remain silent or respond to defend the credibility of the judiciary?
Judges, thank you, Commissioner. Judges are known to speak through their judgments, and rarely today go to public to answer to criticism and all that. But what I know is the judiciary has a spokesperson. They normally they are the ones to be used to answer that. But judges have no latitude or have no way in which they can answer that.
Now, if the judiciary itself is facing allegations of corruption and declining public trust, what immediate and long-term reforms would you recommend to restore the credibility of the institution?
Thank you, Commissioner. I think we already have programs to fight corruption. We already have, so it's a question of now sensitizing. It's a question of sensitizing, and because I remember, like recently, the CJ directed that we need to have, you need to form anti-corruption committees in each and every court, which we have done, and this plays a very important role in terms of fighting the scourge of corruption.
Okay, and finally, how would you use your position as a Supreme Court judge to mentor young judges to strengthen the jurisprudence consistently across the lower courts?
Thank you.
First of all, you could also tell us what do you understand by mentorship. Then now you could answer the second part.
Okay, mentorship, it's all right. Let me just, mentorship programs, or mentorship is where you have an experienced person, you have somebody who has expertise in the area, you have someone who you revere, who can be able to guide and give advice and all that, and share experiences with the others. So when it comes to now, how would a judge of Supreme Court mentor the others? I think what we need is to have programs to that effect. If like now, if we hold, if we can organize to have sessions, if we can organize to have trainings, maybe through KJA, or organize to have conferences, that would be very, very important, and will have mentored the upcoming judges.
Okay. Thank you. I wish you all the best, Judge.
Thank you.
The Vice Chair.
I hope you are not tired. can relax. It's almost over.
Thank you. I've been kept, active, so I'm not tired, Commissioner. Thank you.
Thank you. Now, what makes a judge credible among peers?
Of course, the way you relate with the way you relate with them, the way you do your things, the way so you are a credible. If you are a credible judge, you are able to relate with the others respectfully. You have to have integrity. You have to have collegiality and all that. And even the question of mentorship, you also play a role in mentoring, yes.
Mm-hmm. And how do you ensure professionalism in your court?
Thank you, Commissioner. I will strive to apply the law. I will strive to maintain, the standards required of a judge. Thank you.
Okay, thank you. Thank you, Honorable CJ.
Yes, thank you very much, Judge and the commissioners. I think this brings us to the end of this interview. But we always give a candidate an opportunity also to engage us. You now have the floor.
Thank you, Chief Justice and Chair of the Commission. What I can say is thank you very much for according me an opportunity to appear before you twice this year. And I don't take it for granted. And also thank you for giving me a listening ear. And I hope things will go well. I'll be lucky this time. Thank you very much, CJ.
Welcome. On behalf of the commissioners, we wish you well.
Thank you.
We wish you success in all your endeavors.
Yes.
This being a competitive exercise, we will get back to you when we complete it.
Thank you.
Yes, you are now released, and take our greetings to the people of Nakuru.
Thank you, CJ.